before us. Mr. Castellano, before we speak, if you would confirm that you represent the appellant in this case,
Yes, Your Honor, we do.
and would you like to reserve any time for rebuttal?
We'd like to reserve 5 minutes, Your Honor.
Thank you, sir. With that, the court is ready to proceed, and the floor is yours.
Thank you, Your Honor. May it please the court, counsel. My name is Nicholas Castellano, and I represent the appellant in this case, abbreviated to JJ for confidentiality purposes. Would Your Honors care for a brief recitation of the facts this morning?
I think we're fairly on board on those.
Okay, thank you. Your Honors, while we do have discrete issues of law and fact to discuss this morning, one of the things I wanted to impress upon the panel is that ultimately appellant's position on our reading of the law is that is twofold. Number one, our position is that the agency failed to abide by the mandates of Florida Statute 120.57, specifically subsection 1L, in modifying findings of fact made by the administrative law judge at our final hearing.
And Mr. Castellano, let me see if I could just kind of zero in for the issues. As I understand this, there's no issue at all that your client, it's no dispute that he was, rehabilitated. There's no, that point of contention is out the door. Everybody agrees he's rehabilitated. The question then becomes is, number one, whether the agency was acted reasonable. I guess that's the language, reasonable in denying his exemption. So let's zero in on that and help me out. What facts were presented in the hearing before the administrative law judge that indicated that there was some issue with his violation of probation? Let me backtrack. As I understand the agency's position, they denied the exemption based on the fact that the violation of probation reflected a preponderance of the evidence that he was found guilty of sexual assault. And I believe based on that, they came to the conclusion that it was unreasonable for the administrative law judge to grant the exemption. That's one of the things I think that they zeroed in. So let's focus on that sub-issue. What evidence did the DCF bring forth at the evidentiary hearing before the administrative law judge to reflect, number one, that the violation of probation for that new arrest, there was in fact a finding by the trial court that your client did in fact commit the sexual assault? Help me out with that.
Yes, Your Honor. I think you've zeroed in on it exactly, and we agree as well that this boils down to, was the agency's use of discretion reasonable? Ironically enough, and the agency's position has changed during the course of this case. So initially, when our client made the application for exemption, it was denied. I believe the exact language of the agency was because he was not sufficiently rehabilitated, despite all of the letters of recommendation he submitted, despite everything else he submitted. As we got into the final hearing with the ALJ, that changed. And what we believe the agency has attempted to do is use this violation of probation as a way to, in effect, find my client guilty to some standard of sexual assault on a minor. Our position is that's completely, it's very far from the truth. So ultimately, we're looking at—
Can I stop you for a second? Is it that they're saying that he was effectively found guilty, albeit by a preponderance of sexual battery? Or is the agency's reason that he was untruthful, supposedly untruthful about the reasons he was fucked?
So, and that was the next defense. As we moved to this appeal, the position changed from, well, he was guilty of this sexual assault at the ALJ final hearing, at the DOA final hearing, Now on appeal, the argument, I believe, is we are finding, even though he's completely rehabilitated, we agree with that now, we're still denying the request because of his lack of candor on the application. That's where we hit, I think, frankly, our strongest point, which is the ALJ made specific factual findings related to my client's candor on his application. Those were in paragraphs, I believe, 28 and 29 of her recommended order. In the agency's final order, they did not specifically address those factual findings, and instead, in the final order, made conclusory statements that he failed to, he lacked candor on his application. He failed to, bring this to the agency's attention. He was trying to hide this violation of probation. Ironically enough, so our number one problem is that under 120.57, the agency, in order to modify a finding of fact by the ALJ, they have to state with particularity, after a review of the entire record, why they are modifying or changing that finding of fact. And that wasn't done with this point specifically, that he lacked candor with regard to his application. Furthermore, I think it's ironic that the only documents we have that the agency now is attempting to use to effectively find my client guilty of this heinous crime that he was never actually charged with was provided to the agency by my client in his application for an exemption. These documents that were, there's essentially two orders of modification of probation that we're talking about. Here's the problem with these orders, and this is why the ALJ, there was so much confusion in the recommended order about.
Yeah, and so I guess, Mr. Cuss, I'm trying to find out, is the agency's position of denying the exemption, was it based on your client's lack of candor, or was it based on a finding that he did violate his probation by committing this crime by the preponderance of the evidence? This is what I'm trying to find out, because it appears it's unclear to me. And if we go through the dishonesty point, they zeroed in on, okay, he prepared an affidavit and they took issue with the fact that the affidavit mentions that he was violated because of failing to pay restitution. Nowhere did he mention the fact of this violation of probation or the arrest that has occurred. Interestingly, is that the affidavit, it makes reference to attachments, but the attachments are not part of the record. So that's what's a little bit unclear as to what was the department's position. And if it's on for his dishonesty, well, let's then at the hearing before the administrative law judge, I think at that point he indicated, no, by the time I came through, my restitution is all paid for. So this is where I'm having problems with what is it that they rely on in denying that exemption?
Right. And I think the answer is that a lot of this is very unclear for two main reasons. Number one, if we look at the orders of modification of probation that were entered, those orders were only entered 3 years after this arrest happened. And the state circuit court, Hillsborough County, addresses that in their kind of written order of violation of probation, where they say that after a November 23rd, 2005 hearing, the court entered an oral order modifying the terms of probation, but there was no written order until this one 3 years later.
And what's interesting, Mr. Casa, this written order that's in the records unsigned, is there a signed order?
So I don't know. The other problem was, I know my client at the application stage, when this all started, attempted to retrieve all these records and produced, everything that he could get from Hillsborough County. But because of the age of the records themselves, a lot of them, have been destroyed, or they were on microfiche or whatever the case was. but his case, and I think too, because it was a violation of probation, it was tied to the 1998 original disqualifying offense. And so now we're, 23 years down the road, and those documents, and may or may not exist. But all of this, as far as the agency's contention that he was hiding the ball or he was trying to not to disclose this, he provided all these documents to them at the application stage.
And wasn't there a finding of fact by the administrative law judge that she found him to be truthful? She found him to be straightforward, that he did not hide any of that. So we have that finding by the trier, lack of the better term, a trier of fact. Okay, I'm just trying to follow that. So we have an unsigned order that reflects that there's a violation of probation. We don't know what the finding of the violation is, whether it, and you've indicated that in your brief that this was modified, and in order for a sentence to be, for a probation to be modified, there was not a specific finding of a substantive charge or a new charge. So we have no records before us to reflect the underlying reason for the violation, for the finding of the violation of probation. Am I accurate in stating that?
I think so, yes, because a lot of the contentions that are being made here by the agency that he was found guilty by a preponderance of the evidence, those are being drawn by references to case law, but there's no language to that effect in either of these orders. To be fair, Your Honor, there's two orders of modification of probation. I don't know why there's two, but there's one of them is.
Yeah, and it doesn't, it's unclear, was he violated because of failing to pay restitution? Was there another violation of probation for this arrest? It's unclear on this record what we have. And if you go back as what was provided, there was some document that indicates that, okay, he hasn't really finished his restitution amount. There's things that were checkmarked that were ongoing still. So the question begs the question that at the time he prepared his affidavit, was it accurate? Because it did reflect at one point that he was not compliant. He did not pay all of his restitution amount. So that's unclear. So with all of these unclear, can we at this point in time, does the agency have enough to support? Is there, let me rephrase it this way. Is there any evidence in this record for us to review to support the agency's conclusion of overruling the administrative law judge and to restate the exceptions? This is what I'm zeroing in on, that what is it in this record that we could review?
Yeah, the only thing we have, if I look at the signed order of modification of probation, it's confusing because it says this cause was considered on a request to modify the terms of probation, which was ordered for a term originally in 98 of 15 years. The probation is modified in accordance with section 948.03, which I believe is the statute we referenced in our reply, just regarding how the modification works and the fact that if we really want to try and connect the dots as to what was being found, this type of modification under the statute would qualify as a technical, non-serious violation of probation. But anyways, that's really all it says. There's nothing in either of these orders that say we find by a preponderance of the evidence that he was guilty of the underlying charge. There's no language to that effect whatsoever. I think if we had a copy of the transcript from the hearing, if we had a contemporaneous order at the time the hearing was done, things like that, we could certainly find out exactly what happened, exactly what the judge found, what the circumstances were, what the arguments were, what the issues were to be decided. We don't have any of that. All we have are orders to modify probation, and the modifications, are frankly pretty benign. They did not change the term of the probation. It stayed for 15 years, which was originally ordered in 98. There was no contact with the alleged victim. There was no unlawful or harmful or inappropriate contact with any minor, which frankly, I don't even know if that's a probationary term. That just seems like the way people should go about their lives. He can continue serving as a volunteer athletic coach. He couldn't do one-on-one training with a female minor except for an accepted individual. That was it. And, all of this discussion underscores the fact that he completed the terms of this probation and 10 years have passed. And, he's found himself to be an exemplary member of society. As I think the ALJ really detailed out, there was a mountain of testimony regarding what a positive effect this person has on our community, specifically as it relates to children.
And Mr. Castanet, the fact that there was a condition of no one-on-one with any female minor, can we extrapolate anything from that regarding as to what transpired?
The only thing, and again, I think we're making assumptions at this point because we don't have those underlying documents, the hearing transcripts, or any of those things to know really what happened. I would assume that's based on the allegations that were made. Appellant did testify to the fact that the alleged victim, he actually coached her child decades later, I think maybe 4 or 5 years ago. And she was well aware of it and had no problem with it. And, for whatever that's worth.
Just in case you missed me, we passed 15 a little bit ago.
Oh, thank you, Your Honor. Thank you. But
I know I was engaging in the participation. I was just trying to do the alert. We're at about 16 and a half, so and I realized that maybe I did not speak loud enough. I was being polite maybe for once.
no problem. I appreciate it, Your Honor. But I think going back to that, is it reasonable for DCF to disqualify this person from a job he's held for 32 years successfully? He's done a fantastic job. He's a pastor at his church, works with the children's community at church. His only disqualifying offense is a nonviolent, financial related offense from over 24 years ago. What bothers me in this case is that I think there's an attempt to find him guilty of something that not only was he not convicted of, but he was never even charged with. The state declined to press any charges. So I hope I've been able to answer your questions. If Your Honors have any last questions, I would like to use my time to answer those as well. Thank you, Your Honors.
I think we'll save the rest of your time for rebuttal, counsel.
Thank you.
We will now hear from Attorney Fields.
Yes, may it please the court. My name is Deanne Fields and I'm representing the Department of Children and Families in this matter. And I wanted to briefly take some time to clarify some questions that Justice Kazam has already asked. And that first clarification was whether or not the department's decision was based on appellant's apparent dishonesty or the nature of the offense for the sexual battery on a minor arrest. And it's the department's contention that both matters. If you look at paragraph 28 of the final order, not only does it address the crime of dishonesty, it also addresses the subsequent arrest involving the minor. The department's goal and the department's mandate is protect children and vulnerable adults. I do not believe that the department was being unreasonable when it rightfully looked at appellant's subsequent arrests, which we're allowed to look at arrests. The statute 435.07 does not require that for an arrest subsequent to a disqualifying offense, that the person be convicted of that offense. It doesn't require that they be charged with the offense. It does allow the department to consider the nature of the offense if they're arrested for a subsequent disqualifying offense. And the department did consider that. The other question is whether or not the appellant was found guilty by preponderance of the evidence of sexual battery on a minor. And if we look at the order on violation of probation, which I understand was not signed, unfortunately, that was the only copy that the clerk had. It was admitted into evidence, and there was no contesting at the final hearing of the authenticity of the document by appellant. It does state that the hearing was based on the affidavit of violation of probation. The affidavit of violation of probation, which was admitted into evidence as Exhibit 3, is for sexual battery on a minor. So the order does indicate the reason for the hearing. Appellant also testified that he was represented by counsel at the hearing, that he presented witnesses, character witnesses at the hearing, that the alleged victim testified at the hearing, and that his counsel had the opportunity to cross-examine the alleged victim in that hearing.
And I guess, and I suppose, Ms. Field, this is where I'm having a problem, is that I have Judge Casanueva on this panel, former trial court judge, who preside over many violation probation hearings. And we all know that once you go in and at the hearing, things come up. We don't know what was presented. We don't know what was discussed. Granted, we do know that, yes, the victim was there. The alleged victim was there. Yes, there was, he also had another person there, but we don't know what was discussed there. And we don't know what yes, it made reference to the violation of probation, the actual, itself. But again, not knowing what was presented. And many times things are handled very loosely there, where sometimes, even though you have witnesses, you have the judge saying, okay, here's the deal. Okay, I don't find any evidence of this, but you know what? The victim's here. Don't have any contact with the victim. Don't do this, don't do that. No coaching, no this, no that. But no, and for you to make the leap that there was a preponderance of the evidence that he was found guilty of this offense, that's where I have a problem, because where are the records? Where are, the department could have simply brought in somebody, maybe the former, a prosecutor, maybe something, any evidence that will reflect the department's position that there was a finding by the preponderance of the evidence that he did commit this crime. We don't know that. And that's where I'm having issues with.
And the department understands the court's position on that. Unfortunately, the department was limited to the records that were available in the proceeding. The prosecutor that was involved in the Sarasota case for the sexual battery on a minor was on the department's witness list. This case was one that was continued several times. And unfortunately, at the last hearing, she could not make it. However, setting aside all of that, even setting aside the finding of a preponderance of the evidence that he committed the sexual battery, let's eliminate that evidence from consideration. What we have is an applicant who wants to work with children, who has been arrested for sexual battery on a minor, 2 counts, who has had his probation extended by 5 years. If it was just limited to the additional task of having the evaluation and having no one-on-one contact with female athletes to assuage the court's concerns, then the department could see that, okay, maybe they did not give any weight to these charges. However, appellant's probation was for 10 years originally on the grand theft charge. The court extended that probation to 15 years. They added an additional 5 years of probation. I don't think that is to be taken lightly. The department has a very heavy burden in determining who should receive an exemption. Applicants are not entitled to an exemption.
And I appreciate it, Ms. Yu, but again, it's not something that happened now. If this happened now, and in the last 2 years, last 5 years, you could see the department, but we're talking about, and this is kind of another interesting thing. The department took the position that the actual job that he had to undergo a background check every 5 years. That never happened. So suddenly now, 32 years, I forget how many years later, the department is going back on an incident that occurred way back when. And so we just have to make sure that he's worked with all of these kids, and everything that has been done has been exemplary. So is it reasonable for the department to say, even though he's done all that, oh, let's go back several years ago, more than a couple of decades ago, on a matter that we don't know what transpired, we don't know what was said, we don't know what was presented, we don't know why the reason of the extended probation. Could it be because of restitution, even though he testified that his restitution was all stand up? We don't know that. And we don't know what was provided. That's where we have to be, we have to provide due process to people. We have to make sure that the rules are followed. And I appreciate the department's concern, but this happened quite a while ago. So what is it? Doesn't the department bear the burden? When you mentioned about you had the prosecutor didn't show up, to testify, who bears that burden to show what transpired at that time?
Actually, the applicant bears the burden, not the department. He's asking for an exception to a statutory prohibition against him working with children. It is the appellant's burden.
Ms. Fields, I think you misunderstood me when I say the burden, because you're saying about you're banking, the whole thing is on this violation of probation, that it was extended, it was this. In order for you to rely on that, don't you bear the burden to show what was transpired at that hearing, to come to the conclusion that because, the probation was extended, clearly you're making some assumptions. This is what I'm driving at, not who bears the burden overall. I want to make that clarification on this.
Yes, and I still find that the arrest alone is enough for the department to hang its hat on. Appellant was arrested for sexual battery on a minor for 2 counts. This arrest was significant enough that not only was his probation, an affidavit of violation of probation filed, there was an evidentiary hearing on it. Regardless of what happened at that hearing, if the department, I believe, is reasonable in finding that we cannot gamble the safety of children on whether or not there was a specific finding. Regardless of what happened at that hearing, we can't gamble the safety of children on appellant. And as for, I understand that appellant worked with children for several years. However, the burden was actually on appellant's employer to submit appellant for frequent background screenings, and his employer did not meet their burden. The department can only conduct a background check when a background check is presented to it. Appellant's background check was not presented to us until 2021, and that is why it took so long between 2005 and 2021 for him to receive a background check. 2021 is when we received the request for the background check. So we had no idea whether or not he was still working at this facility. We did not know whether or not he had contact with children. It is up to Sarasota Parks and Recreation to submit that information to us. And then when we get the information, we have to make a judgment call on whether or not we're going to make an exception to a disqualification. And with the nature of appellant's arrest for sexual battery on a minor, regardless of how long ago it happened, we still have to decide whether or not that gamble is worth it. And one thing that concerns the department is that this alleged offense occurred when he was in a custodial position as a school security guard over this minor. And he's asking to continue to directly supervise minors, under which he has a custodial.
And I want to make sure I understand you, Ms. Fields. You're taking the position, regardless of what transpired, the violation, let's throw all that aside. You're taking the position that the arrest, by virtue of the arrest itself, that is enough for the department, for the agency to say the exemption is not warranted, just by virtue of his arrest. Is that your position?
That is our position. 435.07 supports that position, and that we are allowed to consider subsequent arrests in the nature of those arrests. If appellant was arrested for shoplifting.
I'm sorry, but Ms. Fields, isn't
Yes.
that in the context of determining whether he's been rehabilitated? Wouldn't it be inconsistent to say that he's been completely rehabilitated if you're going to rely on that finding, or if you're going to rely on the fact of the arrest?
I believe it can be not just initial rehabilitation, but also on whether or not we should grant the exemption. There's case law that supports this. JD versus the Department of Children and Families, which is cited in the department's brief. It's 114 Southern 3rd 1127. In that particular court case, the JD, the appellant, was found to have been rehabilitated from her disqualifying offense. However, the court found that the department was not unreasonable in denying her exemption request because it stated with particularity the reasons for denying the exemption. And one of the reasons was the nature of one of the offenses, which was child abuse.
Counsel, I have some questions regarding the matter, and so bear with me. I hope I will give them the right context to you. As I review the case, my concern is the absence of records for the 3 years regarding the VOP hearing. And I know you could have probably tried to bring Judge Foster before us, and I would have been glad if you could, since he's passed. Love to see Robert again. Great man. But he was a trial judge, so I know that was foreclosed to you too. So my concern is this, looking at indicia that I used to look at and other judges did on VOP. The original sentencing, I think the record document is at page 225. At Roman numeral 2, it shows good cause was shown and adjudication of guilt was withheld. That was on a case brought by the statewide prosecutor, the theft case. If you're doing normally a violation of probation and you have an evidentiary hearing or under the rules, and I admit the violation, generally, if you're on probation, you get violated. And the first thing that happens is that underlying withhold adjudication disappears and you're adjudicated for that. So that was one of the indicias that I looked for. And I didn't see that. I saw an order that said everything else is reinstated except it was basically, as you point out, I think a 5-year extension and no contact clause. I looked at the VOP orders and they talked about a hearing. Didn't say an evidentiary hearing, didn't say a non-jury proceeding took place in a violation of probation or any of those words. So some of the magic words, and I think part of it was because Judge Foster was trying to create from memory what took place 3 years earlier. But all the indicia that suggests that there was a belief in the underlying VOP for a charge doesn't seem to be there. And, the affidavit for violation may track condition 5 and say violate the law, but the affiant's testimony says, I believe there's probable cause based on an arrest. And now we have the state attorney's office, electing not to proceed. And then I have a modification. To me, it's a reasonable construct based on and you have to admit it's a circumstantial evidence matter, is that the parties agreed to a no contact clause and a minded to probation because that was the only case presently pending. And that's all it did. Chapter 948 and the stipulation, the parties have no contact with these people or these stops. Looks like that went by way of a hearing based on a stipulation or an agreement or no challenge. It doesn't look like anywhere a trial judge, all those indices that you would look for to say, I find this to be a violation and therefore I revoke your probation, doesn't appear to be there. Instead, we have an extension of a term and a no contact. It looks like they used this case as a vehicle. I hate to say it that way, but as Judge Kazan pointed, sometimes parties get there and say, we want to make everybody happy. We're not going to proceed with this. We don't think, but this gives us an assurance that there'll be no further contact. I don't know how that gives you anything to interpret with. That's my concern. You are being penalized for what happened 3 years ago and no transcript, no records, nothing you can find. I think that through no fault of the departments, a real problem. I think that Judge Kazam's touched on, and I'm also share that concern. I'm trying to figure out what happened, and part of the time you rely on your experience and the nature of the circumstantial evidence of what actually appears before you. I've used up too much of your time, so I'm going to stop and ask you what you were looking at, because that's what I was looking at. And I want to make sure that I put my eyes on what you did in terms of absolute truth. Who said what, where, when, and how, so that you can exercise discretion, not based on a theory, but based on a fact.
We also took into account appellant's own testimony at the final hearing. And in appellant's own testimony at the final hearing, He stated that there was a hearing where the prosecutor and his attorney presented witnesses. He said at this hearing, he elected not to testify. However, the alleged victim did testify. Appellant testified that the alleged victim was cross-examined by his attorney on the allegations of sexual assault. And that is what led the department to believe that there was an evidentiary hearing. Appellant testified essentially that there was an evidentiary hearing.
That they found he committed the violation?
The documentation that we have is unfortunately what we have, because as you indicated, it was memorialized 3 years after the proceeding. And even conceding that appellant was not found to have committed this offense by a preponderance of the evidence, the department can concede that point and still be reasonable in its finding that appellant should not be granted an exemption because of A, the nature of this arrest, and B, the nature of the department's mission. If this were another agency, I don't think we would get there. But based on the department's mission and its mandate to protect children and vulnerable adults, we have to look at this type of arrest seriously, no matter how long ago it happened. And although, yes, we don't know what happened at that proceeding because of the shortfall in records, the department can't gamble the safety of a child on, well, maybe they just came to an agreement.
So what we're saying, and I'm not trying to use your words in any way except to continue our dialogue. We are left with the department between a gamble for the child and the gamble of the appellant to liberty to proceed with his position or job. And I understand there's no right to a government job. I understand that. But that's the balance that everybody's looking at, so to speak, and we can take the gamble out and put balance in, the balance of risk, who it falls on and who's going to bear the burden of losing. You're saying we're not going to let you work. He's going to lose his job based on the mission of the department as well as the nature of the proceedings, that combined factor.
Also, the department's appellant is not qualified by statute for this job. The nature of he has a disqualifying offense, which no one is disputing. He is statutorily already disqualified from holding this job. He is asking for an exception to a pre-existing disqualification, and determining whether or not he should receive an exception to that pre-existing disqualification, we would err on the side.
The use of discretion.
Yes.
And if I may, Ms. Fields, Judge Caswell raised a good question. He received a withhold of adjudication for the disqualifying offense. That means there's not a conviction of that. How does that weigh into the department's position? Because I just want to at least, because this is the initial case, grand theft, and I know you made quite a lot in your brief about grand theft as an act of dishonesty and so forth. Well, if he received a withhold of adjudication, that means he was never really convicted of this crime. What is the department's position for that?
The department has no position on whether or not there was an adjudication of guilt or withhold of guilt of adjudication, because the statute doesn't make a distinction. Under Chapter 435, if there is a plea of guilty, or regardless of whether or not adjudication was withheld or adjudication of guilt was found, then you are still disqualified from that position. So because the statute doesn't make a distinction, the department does not believe it can make a distinction.
I'm going to give you an extra minute since my question was so terribly long and I don't want to use up all your time, and I know you don't get rebuttal. So you're at 21 now. I'm going to say take another 2 minutes in case my question took you off your notepad or the points that you want to make. I don't want you to miss any, because like I said, you only get the one shot, and I've been in that spot. I want to make sure you get that full thing, because sometimes we do ask a lot of questions and you sit down there and say, oh geez, I wish I'd have mentioned that, but I got interrupted.
Okay. The department's contention is that an exemption is a privilege, not a right. And yes, the department is held to an abuse of discretion standard. However, when you have an applicant who has a subsequent arrest for a charge as serious as sexual battery on a minor, 2 counts, and that same applicant received an affidavit of violation of probation, his probation was extended, sex offender tasks were added to the terms of his probation for an underlying charge of grand theft, the department has to use its discretion in favor of the protection of any child or vulnerable adult that the appellant may come into contact with. And the department believes that is not an abuse of discretion based on its mandate from the state legislature.
Thank you. Let me turn off the clock. Attorney Castellano, the time remains for you of 3 minutes. If
Thank
you would
you.
be kind enough.
Thank
Mr.
you, Your
Casa,
Honor.
can I just ask you to, Ms. Fields took the position by virtue of the arrest alone, that is sufficient to deny the exemption. And I know Judge Rossi Newcomb indicated, well, does the arrest deal more with the rehabilitation, that issue? There's no issue that your client was rehabilitated. Does the arrest goes into that prong, or does it go independently that they could use that to deny the exemption?
Your Honor, I think that's a great question, because when I listen to the agency's argument, it sounds like they're deviating from the position they took in their final order and going back to the position they took at the final hearing, which was this arrest was extremely serious and we're basing our decision on that. If we look at the final order, they agree, just as Your Honor pointed out, there's no question that this guy is rehabilitated. No question whatsoever. The evidence was overwhelming. But because he was dishonest in his application, it's on that basis that we're denying the request for exemption. I didn't hear a lot of that in today's argument. I heard more of the former, which is, as you said, the arrest is sufficient enough. I would argue, and I think that 2 cases are extremely on point. The case KJS versus Department of Children and Family Services, which we cited, and the Strickland versus Florida A&M University cases we cited. Factually, the same exact issue came up in both of those cases. And what the court said was, if you have a weighing, I think as Judge Castanueva put, if you have a weighing of those, well, what do we have as far as evidence in favor of the idea that the arrest was so sufficiently severe? We have these orders of modification of probation. That's the only evidence we have. And we've talked a lot about how there's just not a lot of information there. We don't know what really happened. We know that there was a benign modification of probation and that he completed it, and this was 15 years ago, so 2005. On the other hand, there is, again, an enormous amount of evidence that was presented in favor of rehabilitation. We got testimony from the pastor at his church, where he later became a deacon, where he counsels children every Sunday. We brought the parents of, I think, 4 different children that he had coached for a period of 5 or 6 years each, from their younger years up through high school and even college. All of the evidence, and as the ALJ specifically found, not only does this person not present any danger to children or vulnerable adults, he is a benefit to those people. That's really what the evidence showed. Ironically enough, not only is he not a danger, but he has benefited the children of this community for decades. The one thing that is also interesting I wanted to bring up was that, so when I hear that they're making a gamble, I don't know what evidence we have. We have very little evidence that's frankly, empty at best, because we don't know any of the underlying facts that support it. There's orders of modification of probation. On the other hand, we have a mountain of evidence that he's a benefit to the community and a benefit to the children specifically. As part of the modification of probation, the court ordered that he do a psychological evaluation, and that evaluation found, again, that he was not a danger affirmatively, and said, you don't have to undergo any treatment. So again, that is just, you know, I think you're right.
I think we've gone past the time plus a courtesy picture, you have time. And I think the panel's fine with that. I hope the council, because we wanted to hear from y'all. It's very important to us, as we know it's very important to you. We will make sure that we have everything covered, except I have two more people. If you were last, I would probably let both people go on for a while until the judges on my panel try to strangle me. Yeah. But I've let those people be heard too. So I have to bring this one to a close. I have to do that. I'm sorry, and I apologize. I would have liked to have more time for this. This one is a very challenging matter, and I really appreciate, I think I speak for the panel, the way both counsel have presented their cases today. It's been a big help. You've really tried hard to respond to our questions and give us, you know, whatever you want to call it, the quid pro quo or the direct response. We very much appreciate that. It's so refreshing to us when that happens. And so we thank you, but that is going to conclude today. We'll let you transition to whatever it's called, the ionosphere or whatever, back to the other spot. You're welcome to watch. As you can tell, I'm technologically challenged. I don't know what the right words are. But I thank you very much, and we'll do our second case today, which I believe is the
Thank you.
Manatee County School Board.
Thank
This
you.
is
Your
our
Honor.
Manatee
Thank you, Your Honor.
Thank you both.